Supreme Court of India Bhan and others versus Ram Kishan and others. Decided on December 9, 2024 INSC 945. Facts of the case. The appellant is the purchaser of the suit scheduled property under a sale deed dated March 2, 1981 executed by the wife of one Kunwar Bhan, the testator, who was the original owner of the property. Mr. Kunwar Bhan during his lifetime executed a will dated March 3, 1965 in favor of his wife. The will created a life estate in favor of his wife. Kunwar Bhan died on October 11, 1965. His wife executed a sale deed in favor of the appellant herein, leading to the son and grandson of Tej Bhan instituting a suit for declaration that the sale deed in favor of the petitioner is void, and also sought delivery of possession. Trial court relied on decision in Tulsama's case and held that the property given to the wife of Kunwar Bhan is in the nature of maintenance, and such a pre-existing right shall enlarge into full estate. Trial court dismissed the suit. The first appellate court dismissed the appeal. The High Court reversed the concurrent findings of the court below. Findings of the court. Section 14. Property of a female Hindu to be her absolute property. 1. Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited owner. Thus, the essential ingredients for determining application of Section 14 subsection 1 are as follows. Antecedents of the property, the possession of the property as on the date of the act and the existence of a right in the female over it, however limited it may be. Any acquisition of possession of property, not right, by a female Hindu after the coming into force of the act, cannot normally attract Section 14 subsection 1 of the act. Thus, it is seen that the antecedents of the property, the possession of the property as on the date of the act, and the existence of a right in the female over it, however limited it may be, are the essential ingredients in determining whether subsection 1 of Section 14 of the Act would come into play. What emerges according to us is that any acquisition of possession of property, not right, by a female Hindu after the coming into force of the Act, cannot normally attract Section 14 subsection 1 of the Act. It would depend on the nature of the right acquired by her. If she takes it as an heir under the Act, she takes it absolutely. If while getting possession of the property after the act, under a devise, gift or other transaction, any restriction is placed on her right, the restriction will have play in view of Section 14 subsection 2 of the Act. This restriction on her right so provided, is really respected by the Act. It provides in Section 14 subsection 2 of the Act, that in such a case, the widow is bound by the limitation on her right, and she cannot claim any higher right by invoking Section 14 subsection 1 of the Act. In other words, conferment of a limited estate which is otherwise valid in law is reinforced by this Act by the introduction of Section 14 subsection 2 of the Act and excluding the operation of Section 14 subsection 1 of the Act, even if that provision is held to be attracted in the case of a succession under the Act. Invocation of Section 14 subsection 1 of the Act in the case of a testamentary disposition taking effect after the Act, would make Sections 13 and 14 subsection 2 redundant or ociose. It will also make redundant the expression, property possessed by a female Hindu, occurring in Section 14 subsection 1 of the Act. An interpretation that leads to such a result cannot certainly be accepted. Surely, there is nothing in the Act compelling such an interpretation. Sections 14 and 30 both have play. Section 14 subsection 1 applies in a case where the female had received the property prior to the Act being entitled to it as a matter of right, even if the right be to a limited estate under the Mitaksara law or the right to maintenance.